Hello, my name is James Trajari, and I'm the Executive Director at Legal Assistance for Seniors. It is my honor to welcome you to today's program, The Future is Almost Here, Electronic Wills in California, presented by David Little. This is the last in our series of 4 webinars addressing various topics on elder abuse. As you all probably know, when we hold the conference in person, it takes many dedicated people and agencies coming together to produce such a large function. And this webinar series is no different. First, I would like to thank all of our sponsors who continue to support us through this transition to online education. Their continued dedication and excitement for the work we do is amazing. In particular, I'd like to thank our 4 top sponsors: Michael Stevens, Probate and Trust Realtor, our diamond sponsor; Campbell Green, our platinum sponsor; and our 2 gold sponsors, the Tile Shop and Acuna Regli. Michael Stevens has been an incredible support to LAS and is always there to help with enthusiasm. If it involves supporting older adults, Michael is always there with a big yes, and how can I help? Campbell Green has been with LAS long before I came on board. For anything big or small, Philip Campbell is always helping LAS, from emceeing events to guiding the agency by volunteering to be board president. Phil believes in older adults and in LAS. The Tile Shop and Acuna Regli, our gold sponsors, have been supporting LAS's work around preventing elder abuse for many years. They are always there to support this work, and we really are so appreciative that they continue to believe in the importance and value of preventing and stopping elder abuse. We have a whole host of sponsors at the silver and bronze levels that we are so incredibly grateful for. Many of these sponsors have been supporting this work for many years. They are our collaborators and our partners, and they keep us excited to continue to do this work. At the silver level, we have Anderson, Yazdi, Wang, Minton, and Horn; Fiduciary Accounting Services, IMT Associates, and Mechanics Bank. At the bronze level, we have 21st Century Care Solutions, ARM Homes, Center for Elders Independence, Evans Law Firm, Farmers Insurance, Golden Gate Fiduciary Services, John Balquist Fiduciary Services, the Law Offices of Sonoy Rousseau, Merlander Company, the Professional Fiduciary Association of California, and Alameda County Supervisor Wilma Chan. In addition, Golden Gate University was going to host the conference in May, and while that did not happen for obvious reasons, they have continued to support LAS in this webinar series with technical support and serving as the honorary event host. The Institute on Aging and their amazing staff continue to be wonderful partners in providing continuing education units for a wide variety of professionals. Last but not least is the team that contributed their time and hard work over the past several months to transition an in-person conference to an online experience. Greg Bedard, Katie Brady, the entire LAS staff, and our event producer, Becca Bloom from BB Events, and Gracie Quinn from Golden Gate University. As I'm sure you're aware, today's presentation is part of a series of 4 webinars LAS is producing in the coming weeks. They are all free of charge and open to the public, though a donation of $25 per webinar will be greatly appreciated and accepted in order to support our ongoing work. We hope you find these presentations informative and useful. You can register for these webinars by visiting our website at lashighcap.org. That's LASHICAP.org, and going to events. Thank you again for joining us, and I hope you enjoy the program.
Good afternoon. My name is Jenny Pardini, and I am the Community Education Advocate with Legal Assistance for Seniors. I'm delighted to be your moderator. Today, you will hear a 35-minute educational presentation from our guest speaker, followed by a Q&A that I will be moderating. If you have any questions for our speaker, please submit them at any point during the program by clicking on the Q&A icon at the bottom of the meeting screen. If you have any technical issues, you can ask us in the chat, and our technical team will do their best to assist you. All right, let's get to it. David Little is here to share his knowledge on electronic wills in California. He is a senior staff attorney with Hartog, Bear & Hand in Orinda, California. David has been practicing law since 2000 and has specialized in trust and estate law for the past 9 years. He is a certified specialist in estate planning, trust, and probate law. David's practice is focused on estate planning and the administration of trusts and estates, and also in litigation. He currently serves as the treasurer of East Bay Trust and Estate Lawyers, and in the past, president of the East Bay Estate Planning Council. Welcome to the program, David.
Thank you. Very glad to be here. Happy to be presenting today on electronic wills via Zoom. What I want to do is go through basically the evolution of electronic wills generally, and then spend a little bit of time talking about California's proposed legislation. I gave this presentation originally in November of last year, and at that time there was a pretty comprehensive statute, AB 1667, that was going through the California legislature at the time. Just this past week, or rather in August, the legislature had essentially shelved that legislation. We'll get to the details of that, but more generally, what I want to do is spend a little bit of time talking about what an electronic will is, what it means, and whether, regardless of whether there is legislation in California, whether or how an electronic will would be valid in California. So I'm going to share my screen now. This title is actually more relevant now than it was last November, because it's even more tentative. The presentation I gave back then and will be giving now has been provided. I've been given information and been given a lot of help from TexCom, especially with regard to the status of the legislation. So I wanted to give them a little shout out there. So what I wanted to start off with is just sort of talking about how things have become more digitized. Certainly over the past 5 months, we've been, even if we hadn't been before, we've been sort of thrown into this new world where everything is digital. And certainly in my practice, and we've had to deal with electronic documents, and we've had to move a lot of things that were paper-based to a digital format. And it has forced us in a lot of ways to embrace technologies that are already existing, like Zoom, and in order to be able just to do our jobs. Fortunately, for us at our firm, most of our, all of our work is paperless, even though we did maintain paper files. But because our work was paperless, we were able to really move into a digital sort of virtual law firm overnight, because we didn't really have a choice. And we're still there. And I think that we are probably, to a certain degree, never going to really return to the way things were. But a lot of things in our world are still paper-based, and wills are one of them. The legislature in a lot of states has worked on ways to sort of catch up with technology. In California, we have in the California Civil Code, section 1633.7, is the legislation that allows a digital signature really to have the same force and effect as a regular paper ink, wet ink signature. So it's really under Civil Code section 1633.7 that DocuSign can happen. Certainly in our practice, we've been using it a lot more. We've been figuring out what things we can sign digitally and electronically. If you've ever bought a house, you've probably used DocuSign a lot. And it's probably over the past 5 months become much more common. And it's really because of 1633.7, because the law says that if there is an electronic signature, it's just as good as a digital one. So you would think that because of this statute, there really wouldn't be any need to have any kind of legislation that would allow an electronic will or that would make an electronic will valid, because under this statute, it sounds like it already is. The problem is that there are a number of exceptions to the statute. And the very first one is wills. So the first exception to our electronic signature statute in California is that it doesn't apply to wills. So we're back in the paper-based analog world. And so, you know, the law of wills goes back centuries, and it hasn't really changed much over all of that time. But everything else has, including the way that we do pretty much everything. And what the disconnect, and even speaking in terms of our own practice, we can prepare estate plans for clients, and we can send them out to them by email, and we can provide them with the ability to sign a fair number of those documents electronically. But wills still need to be witnessed by 2 witnesses. They still need to be printed out and signed in order to be valid. And the trouble with that is that people just don't live that way anymore. And especially younger generations are used to doing everything digitally on their phones and online. And they don't really think about it in terms of going to an attorney and having the formality of a paper will printed out. So we have seen, not just in California, but globally, we've seen a lot of courts having to deal with this, having to deal with what are in effect electronic wills or testamentary documents that look like wills that are not in physical form, they're electronic. So 2 early cases, or relatively early cases, took place in Tennessee and then in Ohio. And these are states that do not have electronic will legislation. They don't have statutes that make electronic wills valid. But what they do have is the same or similar laws to California in terms of what it takes for a will to be valid. And what happened in Taylor versus Holt in Tennessee was the testator signed the will electronically, and the witnesses were also present. They signed the will electronically also. And in Taylor versus Holt, the court had ruled that these signatures, even though they were electronic, were valid because they passed the state's requirements for a valid signature. And they also allowed the testator to present, to basically create an electronic will that was valid. And then the person petitioning the court to probate the will was able to probate that will, even though it was not it didn't follow the will formalities under Tennessee law. In Ohio, in the state of Javier Castro, what you had was a document that was created on the decedent's phone and was signed electronically using a stylus on this was a Galaxy Note tablet. And what they did was they basically created an electronic signature, kind of like you do when you're buying something and you're using Stripe at the store, and you sign with your finger. That was a signature that was used in Javier Castro. The court found that signature was an effective signature, and that the will was found to be valid under Ohio law. Under Ohio and also under Tennessee law, the statutes that the petitioners used to argue that the wills were valid was the harmless error law. California has a version of the harmless error law, Probate Code section 6110C, and under the other states' harmless error law, essentially what the statutes say is that even if a will does not follow does not fit the valid format, or doesn't follow the formalities of a valid will, it'll still be considered valid if the proponent of the will, is able to prove by clear and convincing evidence that this was the testator's will, that this was their intent. And under both Javier Castro and Taylor versus Holt, the court agreed that that was the case, that even though these were not valid wills in terms of how they were executed, there was sufficient evidence to overcome that presumption. So in California, we have Probate Code section 6110C. In that statute, a will that's not otherwise found to be valid in terms of how it's witnessed can still be valid if by clear and convincing evidence you can show or prove that this was the intent of the testator. California's law is a little more narrow than some states because it only applies to witnessing wills. So in other words, if a will is not witnessed properly, it can still be valid if you prove by clear and convincing evidence that is intended to be the testator's will. It doesn't say anything about anything else with the will. So if the signature or the text of the will doesn't follow California law in terms of validity, 6110C2 will not necessarily be able to help. So an electronic will in California that has an electronic signature and electronic witnesses may not work. Even under 6110C2, you wouldn't be able to argue that it was the testator's will. So then we have probably the one statute that a lot of courts have relied on outside of California to find a valid will. And that's the state of Horton. State of Horton comes out of Michigan, the Michigan Court of Appeals. In the state of Horton, the testator had written a note using his Evernote app on his phone. And in that note, he had written details of who he wanted to get his property. And then he wrote a handwritten note directing the reader to open up Evernote and look at a note that was entitled Last Note. And the combination of those two documents, just to back up, Michigan didn't and still does not have an electronic will statute. So the petitioners had submitted to the probate court in Michigan the handwritten document directing the reader to Evernote, to the Evernote app, and then the actual Evernote entry entitled "Last Note." Evernote, if you know what Evernote is, or if you don't know what it is, it's a note-taking application that you can download on your phone. It's also a website. It's a very comprehensive app, and a lot of people, especially in a few years ago, it was a very popular note-taking app. It still is, so under the Court of Appeals, well, we'll back up a little bit. So the document in the Horton case didn't have a signature. And as I said before, there was a handwritten note, and then there was the actual entry in Evernote. The court, under Michigan's harmless error statute, had reviewed and had concluded that it did follow the requirements for a valid will. There was clear and convincing evidence that this was the testator's intent, that was what he wanted. And it had all of the other requirements to make it a valid will under Michigan law. And so it was found to be valid. So here are an example of 3 different states that did not have legislation allowing electronic wills, where documents that are in effect an electronic will, even though they're not formally wills, were found to be valid, and found to be valid under existing law that allowed documents to be admitted as a will, even if it was not otherwise a valid document. So with all of these changes, with documents showing up in electronic form that are being presented to courts as wills, as testamentary documents, courts realize that they need to catch up with technology. And so a lot of states have introduced electronic will legislation. Currently, that's 4, not 3, states have valid electronic wills statutes in place. Florida is the most recent. So Arizona, Florida, Indiana, and Nevada all have legislation allowing electronic wills. California, the District of Columbia, New Hampshire, and Virginia have pending legislation. DC actually, since the coronavirus, has enacted emergency legislation temporarily allowing electronic wills. I think that temporary status is just open-ended. So at some point, the enacting legislation may change, either if they enact permanent legislation, or if for whatever reason they conclude that the circumstances under the coronavirus restrictions are no longer in effect, and then that the temporary legislation will be allowed to lapse. California did not enact any emergency legislation with regard to testamentary instruments related to the coronavirus. One push that people had tried to get through was emergency legislation for remote notarization of documents. Notaries won't help you with a will because wills are not notarized, but that was not found to be, the legislature didn't take that up and push that. Nevada does allow electronic notaries. New York State has passed emergency electronic notary legislation, but California never did. So we are in California, we still have the same law that we always had in terms of not only wills, but also in terms of notaries for documentation. So aside from this patchwork of state by state legislation, the Uniform Law Commission has drafted proposed Uniform Electronic Will Act, and it's a fairly new legislation. I think that it was originally drafted in 2017. I don't think it's finalized. I think that it's still being modified. It hasn't been adopted in any state. It essentially takes a lot of the Uniform Probate Code language with regard to making a valid will under the Uniform Probate Code, and then it adapts it to electronic format. And it also allows flexibility for states to adapt certain provisions to their own statutes, to their own statutory framework. California is not a Uniform Probate Code state. We have not adopted the Uniform Probate Code, although a lot of our statutes are similar to statutes in the UPC, but it is not a UPC state. So that brings us to California's legislation. California's legislation was originally introduced back in February of 2019, pre-COVID, and it was initially a very comprehensive standalone statutory framework for electronic wills. And what I mean by that is it was a statute that really didn't really mesh with the current statutes in terms of what makes a valid will. So under a valid will, a valid will has to be signed by the testator. And rather than adapt the existing probate code statutes regarding signatures of a will to say that that can include electronic signature, the original statutory framework of AB 1667 simply had a whole new provision saying a will includes an electronic will, and these are all the things that make an electronic will valid. The original legislation had information or had requirements for witnessing that allowed witnesses to also be remote. So you could have a testator in one location and witnesses in another. And what the statute was intending to allow was for people to witness wills by something like Zoom. And at the time, in February 2019, many fewer people used Zoom, and it wasn't really that well known. And I think that at that time, the reception to people witnessing wills remotely by some sort of video hookup on your computer seemed really esoteric. And so the legislature had a really hard time with that one. And they didn't like the idea of somebody not being in California, not really being required to be anywhere specific, not even in the US, witnessing a will in California by video, in effect by Zoom. Although you could use any remote technology like FaceTime or WebEx or any other way, so that so long as the witness was able to see the testator sign the will, and then they would sign their own witness attestation. This was very controversial in California, and ultimately it slowed down the debate over this, slowed down the legislation. Another issue with California's original legislation had to do with how to revoke an electronic will. Under the current probate code, for a physical will, it can be revoked by a subsequent will that revokes all prior wills, or by destroying the will. And the question arose, how do you destroy an electronic document? How do you ensure that that happens? Some states' legislation has, some states that have proposed, or even some that have enacted legislation, have proposed a framework or a scheme that would allow some sort of special software that could specifically delete a will, either by some sort of button that you would click on to delete your will, or some other software mechanism that would take care of deleting or revoking a will by effectively destroying it in a digital form. The problem with those with that legislation in those states is that there really is no software that can do that, and so it is an attempt, I think, for these states to sort of legislate, to sort of future-proof this legislation, but it doesn't necessarily make for elegant law writing. So California also struggled with that, about how to draft that language to revoke an electronic will. The multiple versions of the statute in terms of attestation and revocation, revisions to the amendments, rather, to the legislation have gone back and forth, but they weren't ever able to resolve those two issues. So what has happened was, at the end of the legislative session, which ended at the end of July or early mid-August, the legislature decided what they would do was they would essentially punt, and they redrafted the AB 1667 to request that the Law Revision Commission study the issue, and they gave them until September 30th of 2022 to study and then come up with recommendations in terms of how to proceed with legislation for electronic wills. And that's where we are today. There's no real statute pending. Nothing is going to be passed anytime soon. So what does that mean for California and electronic wills? Are we ever going to have statutory legislation? I don't know. We don't know what the Law Revision Commission is going to come up with in terms of its recommendations for the legislation. So what do we do in the meantime? As I said earlier, 6110C will probably not be effective like it is, like other states' harmless error statutes, in terms of being able to make an electronic will valid, because the harmless error statute only applies to witnessing of wills, and it wouldn't apply to, for example, the Evernote will would not have been able to have been found valid in California. The other statutes as well, that where the entire document was digital. So you wouldn't be able to use 6110C to get the court to find a will, an electronic will, to be valid. But that doesn't mean that there is no way that an electronic will could be valid in California. And one way that you would be able to do that is if an electronic will was found valid in another state. Under the California probate code and under the Constitution, full faith and credit law. If one state's law finds something to be valid under its laws, then California can follow that. And in an ancillary probate, that's essentially what happens. So under probate code section 12522, if a will is admitted to probate in another state and has been found valid in another jurisdiction, then California will honor that and it will be valid in California. So if you are in one of the states that has enacted electronic will legislation and you probate a will there and you need to have an ancillary probate in California, then that electronic will would be valid in California. Also, if under another state's laws, that will would be valid in California or in that state, then it would also be valid in California. So the estate of Horton, the Evernote will, that will, if under the estate of Horton, there was a need for an ancillary probate in California, they would be able to use that will in California, even though it wouldn't be valid if it were just in California. When I gave this presentation back in November of 2019, I had I gave this presentation to EdTel at their annual meeting, and one of the speakers at the annual meeting was Jonathan Blodmacher, and he had raised made the observation that in California, or most wills, most states, most assets pass under beneficiary designation. So a lot of people have wealth tied up in IRAs and 401ks and other instruments that are that have beneficiary designations. And they don't have a lot of assets that are subject to probate. Probates, as you know, are much more rare than they used to be. They don't, I mean, they're not non-existent, of course, but you have a lot of wealth out there in retirement assets. And you can change the beneficiaries of those retirement assets fairly easily. A lot of times you can change them online. You can download forms, you can do all of these things. 401ks, IRAs, life insurance, even pay on death or transfer on death accounts have none of the formalities of a will. And yet they are available to allow people to transfer an enormous amount of wealth with relative ease and to make changes much more easily. And so the larger point was that we can make a lot of we can make a lot of fuss about how to make an electronic will valid, but history has sort of passed this issue by. People have gotten around this. Even trusts, you know, as will substitutes. Nobody has tested whether an electronic signature on a trust is valid, but I would say that I'm not really sure that it wouldn't be, although, but I can't guarantee that it would. No one that I'm aware of has tested that, and I certainly wouldn't try it. But the point is that wills are still around, but they're not as critical as they used to be in terms of transferring wealth from one generation to the next. So I think the legislation should change. I think there definitely should be electronic will legislation. It just makes sense. We'll see what the future holds for California, at least in terms of that legislation. So I think now we would turn this over for questions.
Thank you, David, for that amazing presentation. I was surprised to hear how complicated this issue is. I had no idea that there was so much involved in making electronic wills a possibility in California. Before we get to our audience questions, I want to update a few comments I made in the introduction I gave earlier on David. David Little is a principal with Hartog Bear in Hand. He is the 2020 president of the East Bay Trust and Estate Lawyers and is a volunteer member of the Trust and Estate Administration Committee of the California Lawyers Association's Trust and Estate section. Our audience has many questions, which we'll hope to get all answered in our Q&A. We have a 25 minutes set aside for anything we don't get answered today, we will follow up with guests after the presentation. And as a reminder, if you have any questions, please submit them in the Q&A icon at the bottom of the screen. In order to see both of us on screen, click on Speaker View in the top right corner of your screen. Let's bring David back and get started. Hi, David.
Hi.
Let's get to our first question, which I'm going to go ahead with. Since we recorded early in September, are there any updates you want to share around the process and approaches to electronic wills? Have any changes specifically, or have there been any changes specifically because of the impact of COVID-19?
So since we recorded the presentation, one state has enacted the Uniform Electronic Wills Act. Utah has enacted it. That's the only state that has enacted the legislation. And I just checked earlier today and no other states are even considering it. They're not debating it. So that's one state for the Uniform Act. There are now 4 states that have enacted their own electronic will legislation. Florida was the most recent one. The District of Columbia, and I think I mentioned this in the recording, has enacted temporary electronic will legislation only during COVID. That's the only state that has done that. A number of states have enacted remote notarization statutes. Some of them have been temporary measures during COVID. New York is one state that has done that. Others have permanent legislation for remote notarization, including Nevada. So that's kind of how things have gone. I haven't really seen any other potential legislation regarding electronic wills as a result of COVID, or I haven't seen things moving any more quickly though.
Okay, thank you. Someone from the audience asked, how are you defining an electronic signature? Is it the same as a digital signature through DocuSign?
The Uniform Act doesn't define electronic signature, and California's, at one point, California's proposed legislation, AB 1667, had a definition for electronic signature, but the most recent amendment to the statute has gotten rid of the entire legislation. But I define an electronic signature either as DocuSign or as a digital representation of your actual signature. Sometimes you can use your finger to write your signature in, or to present some sort of electronic version of your signature that would qualify as your signature. It could also include a scan of your actual handwritten signature, but that may or may not constitute it, but typically it's something like DocuSign or something you write on a computer intending that to be your signature.
Thank you. How can seniors be protected from elder abuse with electronic signatures?
They can. I don't really know. I think the short answer is that, I don't think there's any way to legislate around potential fraud or undue influence, whether it's for seniors or anyone. I think that, current law doesn't have absolute protection for paper-based wills or any estate planning documents. And I don't think that if you enact any electronic will legislation, you're going to be able to totally eliminate that. One of the challenges and a lot of the debate around electronic will legislation is centered on how do you confirm that that document is the actual document for the testator? How do you deal with witnessing this document? How do you deal with amending it or revoking it? And there's a lot of talk back and forth about how you avoid fraud in each of these circumstances. The problem with that type of criticism of the statute is that you have those problems now, and any electronic will legislation is going to, it's still going to exist. The question is, how do you draft a set of laws that will allow an electronic will to be valid, but doesn't create more problems than it solves in terms of creating a whole separate statutory framework for an electronic will?
Thank you. Someone asked, is California AB 1667 valid for trusts also, or just wills?
The proposed legislation in AB 1667 is limited to wills. Currently, the statute is, or the proposed legislation is simply to require the Law Revision Commission to study the issue of electronic will legislation and prepare a report no later than September 30th, 2022. And the proposed legislation, which actually is adds a section to the probate code that enumerates the things that that they want the study to include. It hasn't been enacted. It's just a proposal right now. So as of right now in California, there is no statutory will legislation. There's really just a proposed legislation to study the issue.
Right. Thank you. So for assets that don't require a will, but are prepared electronically, such as IRAs, life insurance, etc., does the will have to make it clear that there are other assets that may not follow what the will says?
No, I mean, the wills only apply to assets that are subject to probate. So to the extent that there are, there's life insurance or an IRA or a trust that they simply wouldn't pass by the will. So the will, just whether it's paper or any kind of will, is only going to apply to assets that are going to be in the estate. So they wouldn't apply. So there's no requirement under current law to reference anything outside of the probate estate.
Thank you. Could you explain what a transfer on death deed is? Are there any issues here with electronic signatures?
Well, transfer on death deed for transfer of real property, that's a whole separate issue than an electronic will. Frankly, I'm not up to speed on transfer on death deeds. And I think that they are, deeds themselves have to be signed with a wedding signature. So, and then as far as I know, a transfer on death deed also does. So you can't electronically sign a deed transferring real property in California.
Thank you. If a will is not witnessed, would it still be valid if the written instructions are the clear intent of the person writing it?
For a paper will, if a paper will that is not holographic, that lacks witnesses, wouldn't be valid unless under 6110 you had by clear and convincing evidence shown that the will was the intent of the testator. So we talked about the harmless error rule in the presentation, and for a paper-based will, you would need to prove, because it lacked the properly witnessed will requirement, that there was that there was evidence showing that it was the intent of the testator that this document be their will, even though it didn't follow the witness formalities. Electronic wills, the states that have enacted electronic will legislation, and I believe even the Uniform Act has a provision in it for a harmless error provision that for an electronic will. But again, California doesn't have any legislation on electronic will, so there isn't anything pending in California.
Thank you. How do we keep up with technology? Since wills are often drafted many years before probate, could they get lost as technology changes? And this is a long one, it's got a lot of parts, so I can, I will ask all of it, and if you need me to repeat anything, just let me know. So the question was, could they get lost as technology changes? What about storage? If an electronic will were on a floppy disk, for example, who could now open it? Could you explain how to safely keep a will?
So all of those issues have sort of paper-based analogs. I mean, right now, I mean, I've had more than a few administrations of estates and trusts, for that matter, where the originals couldn't be found. And that is either because they are, you know, they could be in a safe deposit box that no one has the key to. They could just be missing and nobody really knows where they are. You know, the law, if the original will is missing, is that it was presumed destroyed with the intent to revoke it, and you can overcome that presumption. So, you know, the electronic version of that is something being stored on obsolete media or just being lost, period. Is it easier to lose an electronic document than a paper-based one? Maybe. I mean, it just depends on how organized the testator is. I think that, you know, you have those challenges now with paper-based wills. It's just the digital version of those challenges. And this is one of the reasons I think that so few states have enacted this legislation, because the challenge of keeping up with how technology changes, I think that a lot of legislators grapple with that, and then they don't really know what to do, because there's really no way to predict what's going to happen. There's a lot of legislation that has been passed that has tried to deal with you know, technology-based issues, and it quickly becomes obsolete and just doesn't serve the purpose that it did. So the challenges those challenges exist for electronic will legislation. Somebody proposed, I was reading a study about electronic wills, and they proposed that instead of having electronic will legislation, that you in effect have a harmless error rule tailored specifically for electronic wills. So in other words, an electronic will wouldn't necessarily be valid, but in order to prove that it is valid, you have to show by preponderance or clear and convincing evidence that this document was intended by the testator to be their final will. I think that, you know, I don't know how prevalent lost wills are generally, and so I don't know how prevalent they would be for electronic wills. I mean, you're going to have the situation in both cases.
Thank you. The next question is, what are examples of assets of the estate for a will? Would that include authorization to access electronic devices belonging to the individual?
So you're kind of talking about electronic assets and electronic wills. California does have a statute dealing with access to digital assets, the Rufata statute that California enacted. A will has to specifically refer to that statute and give the executor the power to access digital assets. They would then be able to take that, once the will is admitted to probate, they can then access those assets. And if there is ever electronic will legislation in California, you would simply add that provision to an electronic will.
I think I'm reading that question a little bit differently because I feel like the asker may be asking, since there are things that already have designated beneficiaries, and you said that it would only make sense to put in a will the things that would have to pass through probate. Like, what are examples of assets that would go into the will?
Well, assets don't go into a will in the way that they have to be titled in a trust. So a will automatically applies to any asset that's subject to probate, and that's set by statute. So assets that are subject to probate is anything in your estate that isn't otherwise disposed of, through a trust or a beneficiary designation or jointly held assets. So you don't have to do anything with assets that are subject to probate in order for the will to apply to them. It does without having to do anything further. So that would include a digital asset like a bank account online or Bitcoin or something like that was subject to probate.
Okay. And then I'm reading the second portion as sort of it says, would that include authorization to access electronic devices? So I'm reading that more as like, can someone put in their will who can access their phone after they're gone to, log out of accounts or delete things or, really wrap things up for the person who's passed?
Right. So in the will, you can specifically identify that the executor can access your digital assets, and you can be very broad by simply saying all my digital assets, which would apply to the ones that are subject to probate. Or you can be more specific about certain assets. That's the Rufata law that I was referring to earlier.
Thank you. And so the next question they asked is, what if you have a scan of the original signed will, but not the paper copy? Is that considered a legal digital will document?
A scan of a paper will?
Yeah.
So that would be treated like a photocopy, like a copy of a will. And you could print that out. And if you were going to submit that to the court to be admitted to probate, you would have to treat it like a lost will. And then there's additional evidence you've got to show to overcome the presumption that the will was destroyed with the intent to revoke.
Okay. And I feel like that ties nicely to the next question, which is also, how would a person or their estate prove that the provisions in a will were their wish and if the will was not witnessed? So how would they be able to prove that if the person just wrote down their will but didn't have it witnessed?
So you've got your presumption that you have to overcome by clear and convincing evidence. You can do that by getting declarations from people who knew the decedent, and the declarations would say that this, was the intent of the testator. Effectively, I mean, that's probably the best evidence. You could also introduce evidence of other documents that they may have written prior wills that showed the same or similar gifting patterns. Anything that you need to show that this was the intent of the testator. When I've had to go in and use that statute to overcome a improperly witnessed will, I got declarations from neighbors and friends who knew the decedent and who had told them that they could, basically the decedent had told them their wishes. And the handwritten document that we were admitting into probate was consistent with those statements.
I'm going to throw my own little question in before I go to the next audience question, which is, I've always heard that it's better to write something down than nothing down. Would you say that, like, in a situation where the person maybe doesn't have the time to get something witnessed, would you agree that it's good to write something down, or is it really going to make it difficult?
Well, a holographic will, if you just simply get out a sheet of paper, write down, what your wishes are. Holographic wills do not have to be witnessed, so they simply need to be written by the testator and signed by them. So there is no witness requirement for a holographic will, and so yes, I mean, especially if you want your estate to be administered in a way that would be different from how it would under intestacy, which you may or may not know, then yes, I would say that would probably be better than doing nothing.
Okay, thank you. Thank you for indulging my question. So back to the audience questions, which is, let's see, where was I? If a valid electronic will is sent as an attachment to the executor and alternate executors, is there an issue of which, is there an issue of which is the actual original of the will that would need to be probated?
Could you read that again?
Yes. So if a valid electronic will, assuming that this is maybe coming from a state that has authorized this, it's a valid electronic will, right? Because we don't have that in California. If it is sent as an attachment to the executor and alternate executors, is there an issue of which, is the actual original of the will that would need to be probated? So I'm reading that as, I guess the electronic will. So I feel like this question's a little complicated here. I'm trying to guess at what the asker was going for, but I'm actually wondering if they're talking about the copied version, like if something were scanned and sent, and that's what they're referring to as electronic.
Right.
But I think you already addressed that as that would not be considered an original, it's a copy.
Well, another one of the issues about that people raise about electronic wills and electronic will legislation is how to distinguish an original, how to define an original, and how to determine what's an original and what's a copy. As long as you've got two documents that say the same thing, I'm not sure that matters. I think that the trouble is if you've got a document that is being admitted to probate and you've got another document, electronic will, that says something different. And so which one is the one you should be admitting to probate? I mean, that happens now with paper wills, but without each state's legislation is going to address that issue, hopefully, and about how to deal with what they're going to consider an original will for the purpose of admitting it to probate. So you would have to look at the 4 states that have the legislation or the Uniform Act to figure that out, because they're all, if they address it at all, it might be addressed differently. I know that the issue of how to store an electronic will has always been problematic in terms of the debate over the legislation.
And then I think that ties well to this, which is, did the states of Tennessee, Ohio, and Michigan have similar laws as California CC 1633.3B1, which specifically excludes wills and trusts from having electronic signatures? I don't know if you know.
I don't know.
Okay. I was like, that's a very specific question. And maybe we can get back to the asker because it's a very specific question. So let's see. I think I'm going to ask. Well, let's do this one. Why don't electronic wills appear to be moving forward in quite the same way as they appear to be doing in other states? So why aren't they moving forward in California in quite the same way?
I know that before the law was, the proposed legislation, before AB 1667 was changed last August, there was a lot of debate over, there were 2 main areas, and I think I refer this in the recorded portion about remote attestation, about the witnessing requirements for the electronic will legislation, and about the how to revise, or amend, or revoke the electronic will. And I think that they were just unable to really reconcile that, because the versions of California's of AB 1667 sort of changed from a whole different statutory framework specifically for electronic wills to one that really kind of just changed current will legislation to include electronic wills in the definition of wills, and then they just scrap the whole thing. So I think that there's just been a lack of, they've just been unable to reach a consensus on how to legislate these issues, the challenges that I've been describing in answering these questions.
Thank you, David. All right, so with that, we're actually going to wrap it up for today's program and share a few reminders for everyone. First off, thank you, David, for your insightful presentation.
Thank you.
We'd also like to thank our top sponsors. So at the diamond level, Michael Stevens, Probate and Trust Realtor, and at the platinum level, Campbell Green, LLP, Trusted Estate Attorneys. David's presentation and today's recordings will be available on the LAS website within the next week. If you need CEU credits, please look out for the post-event email in your inbox in the next 24 hours. And with that, this concludes our Elder Abuse webinar series. Thank you so much for joining us this fall and learning about so many valuable ways to support our aging community. For any questions or comments about today's webinar or the program as a whole, you can email us at conference@lashicap.org. Thank you again for joining us, and we wish you a great rest of your week.